On behalf of the committee, I would like to welcome Pádraig Muirigh, Solicitor, to discuss the UK's Northern Ireland Troubles Legacy and Reconciliation Act 2023. And I thank you very much for your attendance here today. I know you've been very busy earlier this morning, and we're very thankful that you took time to come here on your busy schedule. And I just wish to explain some of the limitations in relation to parliamentary privilege and the practice of the Houses as regards references you will make to other person or persons in your evidence. The evidence of witnesses physically present or who give evidence from within the parliamentary precincts is protected pursuant to both the Constitution and the statute by absolute privilege. However, witnesses and participants who are to give evidence from a location outside the parliamentary precincts are asked to note that they may not benefit from the same level of immunity from legal proceedings as a witness giving evidence from within the parliamentary precincts does, and may consider it appropriate to take legal advice in this matter. Witnesses are also asked to note that only evidence connected with the subject matter of these proceedings should be given, and should respect directions given by the Chair in the parliamentary practice to the effect that where possible they should neither criticise nor make charges against any person, persons or entity by name or in such a way as to make him or is identifiable or otherwise engage in speech that might be regarded as damaging to that person's or the entity's good name. And members are reminded of the long-standing parliamentary practice to the effect that members should not comment on, criticise and make charge against any person outside the Houses or an official either by name or in such a way as to make him or it identifiable. So I now call on Mr. Muirigh to make his opening statement, please. Thank you.
Just firstly, Catherley and members, I'm honoured to have been asked to appear before this committee to discuss the NI Troubles Legacy and Reconciliation Act 2023 and its repercussion for families. My name is Pádraig Muirigh. Born in Belfast, I was raised in the shadow of Clonard Monastery, which hosted the Secret Hugh Madam's talks and laid the foundations for the peace process that ultimately led to the Good Friday Agreement. So I'm a keen supporter of the Good Friday Agreement, but I want to discuss a number of matters today relating to legacy. And first, that in terms of the Good Friday Agreement, there was one lacuna in that agreement, which was obviously a very important roadmap to peace for us. And that lacuna was the fact that it didn't set in place any overarching mechanism to deal with the past in the north of Ireland. That has led to lawyers in the north utilising a number of what we call piecemeal mechanisms, such as inquests, civil actions, the Police Ombudsman's Office, and to a lesser degree, police investigations to assist families in dealing with legacy issues. None of these models were designed to deal with the past, and we've had to use all our skills to do that. But very importantly, the incorporation of the European Convention on Human Rights into UK law was a pivotal moment, a seminal moment. And that duty was placed on the British government by the Good Friday Agreement. So that has been a very important development. And in particular, that has provided a remedy for breaches of convention rights in the UK courts, rather than the need to go to the European Court of Human Rights in Strasbourg, which was a very timely or lengthy matter. It usually would take a number of years, perhaps 5 years or more. So families in the north of Ireland had a quicker remedy and a better remedy within the domestic courts. The development of Article 2 procedural obligations in particular has dramatically changed the inquest process and has allowed us to have much more thorough, conclusive and effective investigation into the circumstances of death of loved ones. There's much evidence that the current judicial investigative processes have been working well, perhaps too well in recent years. I have completed the inquest into the death of 15 individuals, including 9 people killed at Ballymurphy, Francis Roundtree and Stephen Geddes, 2 children shot dead by baton rounds. And in all 15 cases, the coroner determined that the deceased were innocent and that the force used by the state was unjustified. We've also seen a number of high-profile police ombudsman investigations find evidence of collusion between security forces and police, many successful outcomes in civil actions, and various police investigations that have led to soldiers being charged with serious crimes. The British legal system was not designed or indeed intended to deliver such outcomes in conflict-related cases. It was no longer a weapon in the government's arsenal, as envisaged by Brigadier Kitson, a key architect of counter-insurgency strategy during the conflict. But these legal victories for families have prompted a response or a pushback from the British government. On the same day that Lady Chief Justice Siobhan Keegan delivered the Ballymurphy findings, the UK government announced in the Queen's speech reopening Parliament that they vowed to end the cycle of legacy investigation. This pledge culminated in what is now known as the Legacy Act, passing into law on the 18th September 2023. The Act contains provisions that guillotine existing judicial and investigative mechanisms, such as inquest civil actions, and replace these with the ICRAR. The British Secretary of State will control its budget, shape its caseload, have the power to prohibit disclosure, will have some editorial control over its report. In essence, it's a creature of the executive. It's controlled and must report to the British Secretary of State. The Act also contains one of the most sweeping amnesties introduced in any jurisdiction since 1945, and are significantly more expansive than those brought by the Chilean dictator Augusto Pinochet, according to the Model Bill team at Queen's University. The British government has made no secret of the fact that this legislation was primarily about delivering commitments to protect Army veterans from legal processes. In response to the passing of the Act, a judicial review challenge has been brought by victims against the British Secretary of State at the High Court in Belfast. I am currently involved in that case. A number of human rights organisations have also intervened in the case. The court has heard submissions for 7 days at the end of November. A judgment is awaited from Justice Colton, but any decision is likely to be appealed by either party, and the matter could eventually be determined at the Supreme Court. But this legal challenge has its limitations. If an Act of Parliament breaches the Convention rights, the courts can declare the legislation incompatible with the ECHR. This does not make the law invalid. It remains up to Parliament to decide whether or not to change it. In my opinion, it is likely that the current British government will ignore any ruling by the Supreme Court and will ultimately abandon the European Court of Human Rights. They are intent on a collision course with the courts, just like on the issue of immigration, to generate political capital, in this case as defenders of Army veterans. Whilst Labour leader Keir Starmer has publicly committed to repealing the Act, it is feared by many families that as Prime Minister he may, when push comes to shove, soften his stance and merely tinker with the ICRAR. However, in my view, he may be susceptible to a negative ruling from the Supreme Court, or more particularly the European Court of Human Rights on this issue. Will he want the UK to be a pariah state in the international community? The Irish government, for this reason, and not least as co-guarantor of the Good Friday Agreement, should challenge the UK over the Act through an interstate case to the European Court of Human Rights. There is precedent. The Irish government previously took the UK court in 1971 over the 5 techniques used to interrogate people arrested during internment in the north of Ireland. This has become known as the Hooded Men case. As Kieran McAvoy, Queen's University, has said in the recent Irish Times article, there are some advantages to an interstate challenge, such as the fact there is no requirement for the Irish government to exhaust local remedies before accessing the Strasbourg court. This will mean that any interstate hearing will not have to await the conclusion of the current litigation. Such a challenge may not have any impact on the current British government's trajectory, but may provide an incoming Labour administration with sufficient political cover to fulfil its commitments to repeal this draconian legislation. Finally, I want to finish my closing remarks by reference to a key goal of the Good Friday Agreement, reconciliation. The word appears in the title of the Act. There's a clear tension between the legislation, the intention of the legislation, and the language of the Act. There are many component parts to the concept of reconciliation. It can mean inter-community reconciliation, or reconciliation between the victims and perpetrator of gross human rights violations in the context of post-conflict societies. There are other necessary conditions to reconciliation, such as accountability and the development of a political culture that is respectful of the human rights principles, one in which the universal application of the rule of law is deeply valued and respected. This legislation is a breach of the Good Friday Agreement, the ECHR, international human rights standards, and fundamentally undermines the rule of law. The stumbling block to reconciliation has not been victims exercising their rights to access to justice, but 50 years of state willfully obstructing and delaying justice for families. It is only through independent legal processes that the rule of law is restored. This is especially so in cases where the legal system has previously been employed by the state to deny human rights abuses. As Bob Ferencz, a young prosecutor at the Nuremberg trial, said, there be no peace without justice, no justice without law, and no meaningful law without a court to decide what is just and lawful under any circumstance.
Thank you very much for a very intensive analysis of the issues there, and succinctly put and well put. And just to let you know that our committee has previously written to the Taoiseach and the government supporting fully that they would take such an action in the European courts. And today we've already agreed unanimously and we'll be drafting a letter to our members that all will sign off on, reiterating strongly the points that are made in that regard. So I'll call Sinn Féiner first. Francie, I think it was the floor. Very welcome, Francie.
Pádraig, you're very welcome to the meeting today, and very important to hear exactly the case on behalf of relatives and the fact that the court cases that have happened have been taken by a number of solicitors in this particular way. I think it is very important to recognise the role of the inquest and the fact that that had with families, because it gave them something of information where before that there had been known. But of course the Stormont House Agreement was the one way which actually all of this could have actually been dealt with, but the British government ignored that or set it aside, despite that had been agreed within all parties and two governments within it. But in the light of the presentation from we're here in relation to the role of John Bircher on the line of Canova, first of all, and the meeting with families, and families were very satisfied with the role that he had actually played within that investigation and the role that he was promoting the causes of families. How do you think families would actually now react whenever he is now Chief Constable and seems to be blocking the cases going through the courts and the police withdrawing or not giving evidence to that and blocking information coming out for that? So that'll be my first sort of question. And the other line regards the Irish government role of the interstate case. How strong is that, and what are the timelines that actually they need to meet to actually do that? I understand there's an urgency in that case to actually get that brought forward quickly to make sure that one is that it gives confidence to the families that the Irish government are, as you said, the role within the Good Friday Agreement, but also as a guarantor, but also in the line of actually supporting families in the north who are actually trying to get justice within it. And I know in discussions with the Labour Party in England that I wouldn't be confident that the Labour Party under Keir Starmer will actually block this legislation or change it. As you say, they may tinker with it, but actually as regards responding to it, I don't think I wouldn't have any confidence in that situation. But about the two questions around of the role of John Bircher and as Chief Constable, but also the Irish government situation. Thank you.
Thank you, Mr. Malloy. I'll start with the second question, the interstate case timeline. Families must make an application within 4 months of either the passing of the Act or a decision by the highest court within that jurisdiction. So in the circumstances of the judicial review, which will ultimately go to the Supreme Court, it would be 4 months from any decision in the Supreme Court. However, the Irish government are not involved in that litigation. And one of the arguments for them acting more promptly is that they do not need to await the outcome of the Supreme Court and can go to the European Court within these 4 months. So presumably before January the 18th, the Irish government should act on this. I should say that there are some discussions amongst lawyers and families at the minute that families may also proceed to the European Court in advance to the European Court in advance of any Supreme Court decision, based on the fact that it could be argued that the judicial review or the outcome of the judicial review may not be an effective remedy for families. I did highlight in my opening remarks that the judicial review had limitations and that any declaration of incompatibility wasn't a coercive direction to Parliament, but rather a signal, and that signal could be ignored and probably likely to be ignored by the current British government. So there might be an argument that families can also go in advance of any Supreme Court decision. We're currently looking at that, but I think it's imperative, regardless of any decisions made by families, that the Irish government take this case in any event. And in relation to your first question, in relation to the PSNI, I think that was directed at the PSNI and their interactions with the colonial process. There's a long-standing issue with both the PSNI and the MOD, in my view, willfully obstructing and delaying inquests, in particular the disclosure process. And this is a particular problem at the minute because of this new legislation. We are trying to advance as many inquests as possible before the guillotine date of the 1st of May 2024. This has meant more pressure at all ends on families, legal representatives, on the court service, and also on those agencies who are required to provide disclosure and assist the inquest, including the PSNI. And we have found in recent weeks and months that there have been considerable delays with the PSNI sticking to deadlines set by the court in terms of the production of materials that has been directed of them. In the family's view, this is part of a long game, an attempt to run the clock down. And as you know, the members may well be aware, if these inquests don't conclude by the 1st of May, they won't be allowed to continue. So a cynical view might be that it's in certain interests or certain parties' interest to delay matters and effectively derail the inquest, and these cases will then be put into the ICRAR, which is a much less effective investigation. I wouldn't even call it an investigation, a review of these matters. So families are quite cynical about that approach. John Boucher, on his appointment, made some commentary about legacy and maybe dealing with this issue, but we'll have to see how that plays out. And I think there's a real urgency on the PSNI and indeed the MOD to cooperate with the coroners and deadlines set by them.
Okay, Francie, do you?
Pádraig, thanks very much for the presentation. As Francie said, we have been involved in talks with members of the Labour Party, and I would be of the opinion that Francie has that Keir Starmer will not, he may tinker with the bill, but would not change it, effectively change it, certainly. A couple of other things. One of the excuses for this bill was that there were vexatious cases taken against state forces, and the statistics simply would not bear that out. And I think it was Suella Breverman yesterday made a personal statement in the House of Commons and, said that, it was right and proper that after 40 years these people should not be subjected to any sort of court cases or whatever for murders or whatever they have committed in the past. So there's a strong feeling, obviously, and that was brought through. The other thing is that was one of the excuses, as I said, for bringing this bill. I suppose the other question I have, the body that's been set up and headed up by Declan Morgan, former Chief Justice, and Peter Sheridan is also involved. I'm just wondering, in talking to victims groups and victims, is there much confidence that that body will actually bring anything forward? Because, as you said, the cut-off date is next May 24, and the likelihood is that there will be a process of obstructing cases and running the clock down until that happens. So I'm just wondering, what is the level of confidence that victims may have in that particular group to actually bring forward the issues that they want to see resolved?
Well, in terms of the issue of vexatious cases, it's a matter for the court to determine which case is vexatious or not, and any court or any judge would throw that case out. I gave you examples in my own statistics. I've had 15 deaths, inquest into deaths arising from legacy cases, and all 15, the force used was not justified and the deceased were innocent. I've settled a number of civil actions in relation to legacy matters. All of those were settled successfully, whilst we can't go into some of the detail or the amounts awarded in those cases. There are a large number of cases that had successful outcomes for families. I have yet to see a vexatious case or deal with one. All of these are grounded on allegations of collusion or lethal force used by the state in very, very controversial circumstances. So I reject that entirely, and there's absolutely no basis for that assertion. And it's simply a Tory MP or minister playing politics with this issue. I think your question was about confidence in this new body. I would have to say that there's absolutely no confidence. I've met with a large number of families and relatives in recent weeks since the passing of the Act. Some of these have been one-to-one meetings, others have been public meetings, and I've yet to hear anybody advocate using this new process. And there are many reasons for that. First of all, it is a creature of the executive. It isn't an independent court or an independent body such as the police ombudsman. It is a creature of the executive. And just to give you, it's controlled by the British Secretary of State, just to give you some examples of the powers of the British Secretary of State who was just gone through the legislation in preparation for this meeting. The Secretary of State appoints the commissioners, Schedule 1, has control over information disclosed by the Commission, determines the term and durations of the appointment of the Commissioner, has control over funding, must review the performance of the Commission, may make regulations winding the Commission up. Control the exercise of the Secretary of State over the Commission is also clear from the fact that the Commission must report to the British Secretary of State. So it is controlled by the holder. It controls the holder of the office in many, many ways. So families have absolutely no confidence in that process, and it is a very, very inferior process to the current piecemeal mechanisms that are available for families.
Just one other question in finishing, because obviously the bill looks retrospectively at cases that have happened, particularly in the north, but there is a thought abroad that it also gives impunity to British forces in the future. And I'm just wondering, what is your thoughts on that?
Well, I've no doubt that other countries, I think that was probably the one eye to that when looking at this legislation, not only the conflict in the north of Ireland, but other conflicts that the British Army have been involved in, are currently involved in, and may be involved in the future. And I'm sure other prior states will be looking at this legislation and will want to see if the British government get away with it, particularly this section on immunity. I mean, as I indicated in my opening, the expansive nature of that immunity is much greater than that was used in Chile by Pinochet. And there's actually a lot of case law in the European Court against the exercise of immunities like this. So it's clearly a breach of the European Convention on Human Rights. If they get away with that, I have no doubt that other states will look at that and will be encouraged by that. And also that will have an impact on the role and behaviour of the British Army, not only today, but in the future.
Thank you. Thanks.
Okay, Francis, yeah.
Thanks very much. And thanks so much, Pádraig, for coming in today and to give evidence and for all the work that you do. You do phenomenal work on behalf of bereaved families, and it's so important that we hear from people like yourself that have been working on the coalface of this issue for such a long time. This morning, when we had Relatives for Justice in, I wasn't aware that there was a timeline for the Irish government to make a decision on this, and I just want to kind of ask you, because there is a huge urgency on the Irish government to make a decision on challenging the UK to an interstate case. The impact of the legacy bill on families, as you well know, will re-traumatise the families. I mean, they're already dealing with unbelievable trauma. And I suppose I just think, you know, at this time, the Irish government have a duty to those families now. And I'm worried about the whole Christmas holidays. I mean, we're looking at the 18th of January here. You know what I mean? We're finishing up here next week. I suppose my concern is, like, will this decision be made, you know, before the 18th of January? And can you say a little bit about the urgency of the Irish government to make that decision?
Yeah, there is some urgency. I think the Taoiseach had indicated quite a number of weeks ago that he would only take another couple of weeks. We've passed that. I know that the Attorney General has provided advice already, and now it's probably more of a political decision. I'm not quite sure what that legal advice is, but I mean, in my view, there are very clear grounds for the Irish government to take this case. And other than political reasons, I'm unsure as to why they haven't done it yet. And I think it's incumbent on the members of this committee and also other politicians to keep the pressure on. As you say, we're now heading into a holiday period, and shortly after that, we're close to the 4-month deadline. Now, I should stress that that's the deadline for families applying. My understanding, it's the same for the state, but I stand to be corrected on that. But nonetheless, I don't see any reason why there should be any further delay. The bill is now in act. It's very clear that this act is in breach of the Good Friday Agreement, the European Convention on Human Rights, and I don't think the Irish government should await any Supreme Court decision on that, or wait on the outcome of the current litigation. And the time to act is now. And I think that'll put, not only as important legally, but it'll put considerable pressure, in my view, on the British government, whether probably more likely any incoming British government. And as I said in my opening, that may provide some political cover for any Labour administration to seriously consider keeping to their word, which they gave at Queen's University, to repeal this Act. I have my doubts about that, as some of the members have already said. But without an interstate case, I think the Labour government has an easier ride in terms of avoiding dealing with this issue in any substantive way.
Pádraig, in your opening statement, you mentioned that you qualified in 2009, and so you had several years of practice before the introduction of the Stormont House Agreement. I was wondering, can you speak about how the agreement changed your work and what your work looks like now with the passage of the Legacy Bill?
Well, yeah, I mean, I was actually involved in advising around the Stormont House Agreement. And like everything else, it was a political compromise. It wasn't the perfect resolution, but it was a much better process than the legacy framework after this Act. So, for example, many families would have had inquests as well in the 1970s or civil actions. However, those legal processes were deeply flawed. I mean, soldiers weren't compellable witnesses. Families weren't legally represented. There wasn't funding to have the legal representation. With the introduction of the Human Rights Act and the incorporation of the convention rights into domestic law, and the Good Friday Agreement was pivotal in that, that meant that my work changed considerably. So if I take an inquest, and I know that you're familiar with the Ballymurphy inquest, the original inquest in 1972 was pecuniary in nature. The more recent inquest was completely different. So families were front and centre of that inquest. They were represented not only by lawyers. Those lawyers could make legal submissions in terms of the scope and breadth of the inquest, but they also had forensic experts employed, such as ballistics, pathology, engineers, to recreate the scene. They also had considerable disclosure, which was provided to them, which allowed them to prepare for witnesses. They got access to soldier statements, witness testimony. And the most important part was that they had the facility through a public hearing, which is not allowed in this new process. But that public hearing allowed the process to be transparent, but also the evidence could be examined and tested. So I've often gave examples of a witness who came to Ballymurphy, who provided evidence which, in my view, was to besmirch the reputation of the priest, and claimed that he had gone into the field where another man was shot to give him his last rites, and lifted a rifle beside the man. When this gentleman came to give evidence at the inquest, because we had disclosure and the autopsy report, because he referred to him wearing the priest's robe as he done this and put the rifle up his robe, we were able to prove that that was a lie, because we had the autopsy photographs which showed that he wasn't wearing a robe. We had the witness statements which described this priest's actions on the day. We had the soldier statements. So we had all of that evidence. We were able to dispel this attempt to besmirch this priest's reputation, and we were able then to assist the coroner come to the proper conclusion that Father Mullen was indeed innocent. So that was a very good example of a very transparent process with disclosure, with the opportunity to test evidence, not only, because we often talk about information recovery or these reviews that this body is going to do. Statements are only as good as a statement taker. If they're not tested, if families don't access to all the information around it, we can't prepare to examine and test and get the best evidence. So the inquest process has become, the Ballymurphy model as it's now known, has become the best way to get truth in these cases. And I think it's no accident, on the same day that we got these findings, that the British government announced that they were going to end the cycle of legacy investigations. In fact, I have the ITV report here. At 1:19 p.m. on the 11th of May 2021, the Ballymurphy families left the Waterfront Hall roughly around 1 p.m. or shortly afterwards. Within minutes, this announcement was made, and that has obviously culminated in the Legacy Act. The Legacy Act dramatically changes that landscape. All of those benefits we have received from the inquest, which have led to the findings of innocence, are not available in this new model. It is a very, very different model, and it's designed not to have the outcomes that we've seen in recent years through Ballymurphy and many, many other inquests.
Thanks very much, Pádraig. I mean, I just want to say thanks so much for the work that you're doing, because if it wasn't for people like yourself and Relatives for Justice and other organisations, I just shudder to think you know, where would be the voice for those families? So, you know, you're doing phenomenal work, and I really hope that you can be heard today, and I really hope that, as you know, I'm just an independent here in Leinster House. I really hope that the government can hear, you know, what you're calling for today, because I think it's absolutely vital going forward. And I shudder to think if the government don't take the interstate case, what would happen. So thanks very much for presenting today.
Thank you.
Pádraig Tobin.
Cáthíirligh agus míle buíochas Pádraig gasta chur láthair inniu. First of all, I suppose it's important at times nearly to put the kind of the human face back onto these types of discussions, because sometimes we talk about these issues in legal and abstract terms. But I'm just thinking of one individual, Denise Mullen. She used to be a councillor for Aintu in the Moy area of East Tyrone. When she was 4 years old, the Glenanne gang came to her front door and shot her father dead in front of her, and then tried to shoot her mother dead, but her mother escaped by running across the fields. And Denise, as a 4-year-old, was left on the step while her father was dying for a couple of hours before emergency services came. And you know, I think about obviously the heinous elements of the murders of, you know, Irish people in the north of Ireland by the state. And on top of that massive wrong, there was the cover-up, and the cover-up obviously heaped disaster on top of families. In many ways, families were left nearly to blame for the actions that actually befell them in certain situations. And you know, at the time, those cover-ups, the British establishment could nearly separate themselves, or at least tried to separate themselves from those cover-ups by saying that, you know, the administration in London was not responsible for the micro actions of people on the ground in the north of Ireland. But this bill is the son and heir of each individual cover-up that actually happened on the ground in the north of Ireland during the Troubles. And in this situation, the British establishment can't separate themselves from those actions, because the British government themselves are involved in the cover-up from their chambers in Westminster. And I think that's a significant point to make. The other element in this is, you know, that it is, I suppose, important to say that the Tory government, you know, care little and know little about the north of Ireland. Their major motivation is votes on election day, and that's always going to be the case. And you know, I met with Labour Party peers and MPs in Westminster in terms of this, and I'm left with no confidence either that they will repeal this legislation if and when they're elected to power in London. I suppose one of the issues of frustration for me is that the Irish government has been so slow to act in relation to this. So before the legislation passed, the response from the Irish government was that they weren't going to make a decision on this until it had passed, because they were going to use every diplomatic tool that they had to try and prevent it from passing. But obviously that passing has happened. And even now, we're still hearing a kind of muddled response, I would say, from the government in terms of what their decision is going to be. And, you know, I would just say that it's really important for people, no matter where they are, if they're in the south or in the north or in America, etc., to try to use all the efforts they can to try and get the Irish government to mobilise on this. I'll be raising it in the chamber now in about an hour's time in the Dáil again with the government. But just to confirm, you know, there's maybe a little bit of confusion over this. Is the 18th of January the cut-off date for the Irish government to make a decision in terms of an appeal to the European Court of Human Rights in relation to this, or is there any wriggle room in that time?
There may well be wriggle room. The court basically states that you must take the case within 4 months of the passing of the law, or within 4 months of the decision of the highest court within that jurisdiction. So it's perhaps open to the Irish government to say that the 4 months could extend to them as well, past the Supreme Court. But you know, regardless of any arguments around that, there's nothing preventing them taking this case now. The benefit of it, of course, is because they're not party to that litigation, they don't require to await the outcome of it. So my argument to them is that they should take it, and should take it within this shorter window in the first 4 months after the passing of the Act. They are not part of the litigation. They're not involved in it. They have no rights of audience within that judicial review, and they're quite outside it. So that case should be taken by the 18th of January.
So we have little more than a month in the southern states to act on this, and given that most of that month will actually be taken up with Christmas holidays and elected representatives back in their constituencies and offices closed, we're really talking about a fortnight over that period of time where the Irish government actually has to make a decision on this. So this is critical. And the one point I would say this as well, heaping the responsibility on victims themselves to bring this case to the European Court of Human Rights is an absolute disaster, because the efforts necessary by voluntary groups and campaign groups and to launch such an action is enormous in terms of time, effort, resources, etc. And the level of pressure on a government to do similar is far less intrusive for a southern government to do that. So the onus now is on the southern government to really act with immediacy at the moment. One other question I have for you there is, and I asked this of our previous presenters too, is I'm very much of the view that we need to create an alternative source of justice and truth to the one that's available through London currently. And Aontú has produced a bill that seeks for a commission of investigation to happen in the south of Ireland into people who have been killed and suffered as a result of actions taken anywhere on the island of Ireland. And obviously that commission of investigation would be limited with regards, forcing people outside of this jurisdiction to provide evidence. It could do so, which would be valuable in its own right within this jurisdiction, but it would also be able to take voluntary evidence from people outside the jurisdiction in the north of Ireland and in Britain and in elsewhere. If such a bill was also passed through Stormont, it would then have an all-Ireland element to it in the ability to force people to participate in the 32 counties. And also this particular commission of investigation would allow for all of the evidence that has been produced in so many different locations to be gathered in a central space, to be properly analysed, to then decide on the exact narratives of actions that were taken by the British state in terms of killings north and south. What would your own view be in relation to that?
Well, I'm not resistant to any proposal to advance information recovery, truth, etc. for families. My only concern is that some of the key combatants in the conflict, particularly the Ministry of Defence and the police, will not cooperate with any such inquiry. They won't allow access to their positive materials to such a process, and it's going to be difficult to get the whole picture without all of that disclosure. And that has been one of the benefits of an inquest process, where the powers to compel disclosure are very, very important. I mean, the section, I think it's section 6, states that any material that is potentially relevant should be provided or disclosed. Potentially relevant is a very, very broad test, and that has meant that families have received substantial disclosure, and that is on a legal statutory basis. Any inquiry that is set up, my difficulty will be that the Ministry of Defence and perhaps the PSNI as well won't cooperate with it. Certainly the Ministry of Defence. Without that material, it's going to be very difficult to have a full picture of what happened in terms of the conflict. I don't suspect that they'll cooperate with it, or certainly allow a central depository of all their material on the island of Ireland.
And just one last question. A year ago or so, I brought a number of victims of the Glenanne gang to government buildings to meet the then Taoiseach, which was Micheál Martin. And it was stated at that stage that the Garda force down south were, maybe because of some legislation or regulation, not providing all the documents necessary for investigations in the north. Has all of that been cleared up? Is it a case that there are any blockages for evidence or information to be provided to investigations in the north?
Well, in terms of the Garda, I'm not involved in the cases that you're referring to, so it probably wouldn't be proper for me to comment on that. I just wouldn't have the knowledge or information on that, unfortunately, Mr. Tobin, so I can't help you with that question.
No problem. Listen, Mila Magath for Shane Pádraig.
I
just have one more question for you, Pádraig, and it's in relation to the Good Friday Agreement. And we know that the European Convention on Human Rights is the scaffolding of the Good Friday Agreement. So I was wondering, could you say a little bit, or how do you feel the passage of the Legacy Bill, which is so obviously a violation of Article 2, how do you think that will impact the Good Friday Agreement? Or would you be able to say a bit about that?
Oh, absolutely. The human rights ethos is ingrained in the Good Friday Agreement. I mean, reconciliation and human rights and respect for human rights is central and our key objectives, key goals of the Good Friday Agreement. And I feel that this legislation is the first step to the British government's withdrawal from the European Court of Human Rights. I think that's ultimately their objective, and that would be devastating for the Good Friday Agreement. You've seen it with the issue of immigration. You've seen it with the approach to Brexit. You know, some of these cases, some of the decisions of the Supreme Court were challenged by the government, and you had the right-wing media referring to the judiciary as enemies of the people. This is all classical right-wing, autocratic. You've seen that in other autocratic countries where the judiciary is attacking. The judiciary is a key bulwark against excessive use of powers by the executive. So I think there's a bigger picture here, and I think I referred to my opening statement to a deliberate collision course that this government is having with the judiciary on rights-based issues, and you see it in the right to protest in relation to the Palestinian issue as well. So in the last number of years, there's been a mission creep around rights, and I think they would actually welcome a challenge, even a negative announcement or decision from the Supreme Court. Where they can point to the judiciary impacting on their democratic manifesto to implement X, Y, and Z, which was passed at the elections and supported by the people. That's the kind of language that they're talking. So I think there's a real danger that this act is only the start. And I think I'd done a Zoom call with students from Sheffield around this legacy issue a number of months ago. And they were making commentary about this being devastating for families in the north of Ireland. And I did warn them that this is much bigger, and it's also your problem, because this is perhaps the start of a withdrawal from the European Court of Human Rights. And if that was the case, it is devastating for legacy families, but it's much wider political damage for the Good Friday Agreement. It is a key element of it, which if that withdrawal from the European Court or the Human Rights Act being repealed certainly would be quite a bad political move by the Tory government, but and devastating for the peace process.
Yeah. Thanks very much, Pádraig, and thanks again for the work that you're doing.
Okay, well, I'd like to thank all the contributors so far, and Pádraig, to thank you for your analysis and I'm really impressed by the way you make your arguments there and the logic and the certainty of them. And to assure you, indeed, anybody who might be listening, that this committee is of the exact same mind as regards what the government should do in relation to the European Convention of Human Rights and the need for the government to take that action. And I've no doubt that is happening under a due process. And I don't believe, and I know nobody's suggesting that somebody is trying to delay. I'm happy that the due process is in place. And today is the 51st anniversary of the abduction and murder of Jean McConville on December the 7th, 1972 in Belfast. She was a widow, she was a mother of 10 children, and she was buried in an unmarked grave for over 40 years without anybody identifying the place that she was put in. And I think if anything touches my heart, it is that. Along with all of the victims you so rightly and so properly include in your statement here today. I also remember this committee went and saw where Columba McVeigh, 48 years ago, he was abducted and murdered in a bog, left in a bog in Monaghan, and there is no body found yet. and the pain of the families on all sides by doing evil and appalling acts like that is absolutely cries out for justice. And I would think that anybody who has knowledge of the murder of Jean McConville and of Columba and all of the other people who died in this awful tragedy, over 3,500 people, we need reconciliation, we need truth, and we need justice. But justice must be seen to be done on all sides, and everybody is entitled to that. And I support absolutely what you're saying here today. But I would appeal, that whoever, particularly in the IRA, or former Republicans who know about where Columba McVeigh was brought, who can identify that location. We need more information because you're talking about acres, miles of bog where he's buried in. But the family are entitled to a due and a fair process. They're entitled to be able to bury him in the family grave, and that's all they're asking for. That's all they're asking for, and I think it's incumbent on all of the people of all these crimes that have been committed in the North, that the truth comes out and the families get closure. And I laud and support, your contribution and your work. And our committee is fully behind, what you're saying here today. So I think it's fair to say to thank you again for your professionalism, for your commitment, for your integrity. And, it's 25 years since the Good Friday Agreement. And thankfully, the guns are silent. Parties are participating, some of them, in an elected process, but obviously there are people not allowing that Northern Executive to work. The North-South bodies are in abeyance, and the East-West improvement in relations is very welcome. But we've an awful lot of work to do, and the contribution that you're making is hugely important in that. And I thank you for that, Pádraig. And if I may, then we'll adjourn our meeting now till Thursday of next week at 9:30 a.m. So thank you very much for coming here.